I'd like to invite Professor Pérsio Arida, who is going to present his paper, his speech on revisiting judicial uncertainty thesis. Pérsio Arida is a well-known economist in Brazil. He's both member of the board and officer of BTG Pactual. Among other activities within the federal public administration, he was president of the Central Bank of Brazil and of BNDES, the development bank in Brazil. In the private sector, he was the member of the board of Itaú, Vale, Unibanco, SulAmérica, and as well as officer in several other companies. Pérsio Arida holds an economy PhD from MIT and graduated in economy at the University of São Paulo. He was a professor at the University of São Paulo and PUC-Rio. He was a researcher at Princeton, Washington, and Oxford. Arida has been awarded with several prizes, including the Economist Year Award. So, welcome, Pérsio. Thank you.
Thank you all for being here. It's a pleasure and an honor to be invited for this seminar. What I intend to do here is just to revisit the paper I wrote in 2003 together with Edmar Bacha and André Rezende on judicial uncertainty. Much has passed since 2000 and changed since 2003 up to now. So I think after 12, 13 years is a good time to revisit thesis and see whether the changes actually make it still true or not. Let me first recap the thesis. We started with three stylized facts. First, Brazil had, I'm talking about 2003, extraordinarily high rates of interest, real rates of interest, that could not be explained by the traditional factors like public sector deficit, loose monetary policy, nature of business cycle. Brazil had much higher rates of interest than other emerging market countries. The second stylized fact is that, different from other emerging market countries, financial wealth was held primarily in domestic financial instruments, not in offshore financial instruments. The contrast here with Argentina is crystal clear. Argentina is an extreme case of the opposite, in that the bulk of financial wealth is held in offshore instruments, dollar-denominated offshore instruments. But other emerging markets have mixed evidence, but clearly Brazil is the one that clearly stands as the major case of being underdeveloped, yes, but having the bulk of financial wealth held in domestic currency. The third stylized fact was that duration, that's a technical term, of debt obligations in offshore markets was longer than duration of debt obligations in onshore markets. So for the very same company and the very same acquirers of debt, for the same agency in other terms, for some reason duration was longer in offshore markets than onshore markets. We argue then that it had nothing to do with the nature of the currency, being reais or dollars, but had to do with the jurisdiction in which contracts were signed. Well, those are the three stylized facts. What was the thesis? The thesis is a kind of pretty much simple one. Judicial uncertainty made financial markets short-term. Financial markets in Brazil were developed but suffered from what we could call, quote-unquote, short-termism disease. Long maturity did not exist. You could look at swaps, you could look at debt instruments. Everything was well developed in options, etc. Look at how big BMF was already there. But basically, you're talking about short-term financial instruments. That's the role of judicial uncertainty. The fact that Brazil had resorted for long to capital controls made the bulk of financial wealth being held in domestic currency. Now, the fact that domestic wealth cannot move freely abroad, and you have an uncertainty on domestic judicial system, made necessary for government to pay very high rate of interest to keep, let's say, savers happy. In other words, the very high rate of interest were interpreted as a consequence of uncertainty on the judicial factor and the fact that it had no currency convertibility. That was basically the thesis. And the question is, it was clearly true by then. It was hard to compare to the other countries because we're talking about kind of a certain uniqueness of Brazilian economy as opposed to other emerging markets, in particular Latin American countries. Let me talk about the three stylized pieces of evidence first, one by one, and then check whether they are still true today. First, very high rates of interest. The argument is that, of course, we do not want to underplay the traditional factors affecting interest rates, such as monetary policy, fiscal policy, real business cycle, et cetera, et cetera. But the fact is, those factors explain why sometimes the real rate of interest is above what the equilibrium level or natural level, as the term the economists would say, or below. But the equilibrium level as such was extraordinarily high by then. Is it still true today? No discussion. We have exactly the same issue today. If you ask rates of interest today in 2015, they are a bit above the equilibrium level because you're trying to actually disinflate the economy. But by and large, all estimates of econometric estimates of the natural equilibrium rate of interest in Brazil for the past 10 years show exactly the same pattern that we had in 2003, namely, there's something unique here. Brazil is still the highest interest rate country in the world. And you cannot explain this by the size of public sector deficit, however big, by the fact the central bank is not independent. They all have some influence, of course. But you could easily name other emerging market economies with the same characteristics and exhibiting much lower rates of interest. If you ask why, it's related to the second fact. The second fact, remember the second stylized fact, is the fact that financial health is by force, by capital controls, by legal controls, forced to be held in domestic instruments. That was a strong contrast with other Latin American countries that were clearly dollar-based. Brazil was never a dollar-based economy. Dollar-based economies are economies in which financial wealth is held offshore. Argentina is a crystal clear example. Argentine society, to some extent, if you talk about big savers, etc., it's kind of a rentier society. The guys live in Argentina, but financial wealth is held outside Argentina in dollar terms, the dollarized economy. Brazil has never been a dollarized economy. Has been, not by choice, but by law determination of capital controls, a domestically held financial economy, what were called by then monetary correction economy. That difference explains why the stabilization programs in Brazil are so much different from other stabilization programs in Latin America. All those stabilization programs in Latin America were actually dollar-based. If you look at Argentina, or Mexico, Chile, or Peru, those stabilize inflation by the exchange rate. In Brazil, it was done through the Real program, was based in a paper I wrote with André in 1982, actually, called by then the Larida program. But that's essentially trying to curb down inflation, take into account that you have an economy that's not dollarized. It's based on monetary correction. Is this second piece of evidence still true today? I said, yes, no question about it. Although there was some progress in capital controls, we have less capital controls by now than then. Central bank has engaged in a silent, let's say, dismantling of capital controls, never announced it as such, but has run through different administrations. And today we're less capital controls than before in practice. They could be enacted at any point of time, but in practice have less than before. By and large, still true that in contrast to other Latin American countries, Brazil still has the bulk of financial wealth held in domestic instruments. What about the third piece of evidence? The third stylized fact, namely that we had long-term duration for credit outside Brazil as against short-term duration in Brazil. We have had impressive developments in financial markets in Brazil. 2003, credit to GDP was about 25%. Now we're talking about 58%. if you look at long-term duration credit domestically, it's a larger fraction now than it was before. But if you look more in detail, why credit has longer duration now? Because of BNDES, which is clearly an artificial way of increasing duration of the economy, and loans, mortgage markets, which is clearly the only new developing economy. So if you try to assess if this stylized fact is still true or not, one should look at the average duration of debt in Brazil as opposed to average duration of Brazilian debt held outside Brazil. Let me start with the outside Brazil today. Right? Today, the average duration of bonds issued outside Brazil, of Brazilian companies, is about 5.9 years. That's less than Chile. It's about 6.2 in Chile. As you would expect, Chile is the most advanced country in Latin America from the economic and market organization viewpoint. Not too distant from high yield, American high yields that have 7.7. So all in all, Brazil looks okay from the viewpoint of duration of external credit. There's nothing particularly unique to Brazil in that regard. Less than Chile. Chile is less than US high yield. That's what you would expect. But compared domestically, the average duration is 3 years. So all in all, the discrepancy between the duration of credit domestically and offshore continues. Both maturities have extended a bit, but the discrepancy continues. So of the three stylized facts, we have, I would say, all of them are still true. The question is there any other explanation of higher rates of interest in Brazil, taking into account the three stylized facts or not? The paper had policy recommendations. I have this obsession by policy, so all of my papers have policy recommendations one way or another. There's a negative policy recommendation, a positive policy recommendation. What was the negative policy recommendation? Well, if you have judicial uncertainty, don't try to extend maturities domestically by law, compulsorily, because you actually provoke all the distortions. You have to address the problem directly. Don't try to compensate short-term financial markets by extending by artificial means. The criticism was directed against FGTS, that's our compulsory savings associated with labor income, and against BNDES, that's compulsory savings through taxes and devoted to long-term loans in a development agenda. So basically, the paper is saying that you should dismantle. We didn't say that openly, but should dismantle those two systems, FGTS and BNDES. And you should address directly the judicial uncertainty issue. And you should remove capital controls, because that's the only way you could actually induce a natural lengthening of duration of maturity domestically. Obviously, being economists, we discussed a lot capital controls. Did give any suggestion about how to reduce judicial uncertainty, because it was clear to us what the problem was, but we didn't feel enough expertise to recommend something. Now, if you look at what happened over the past years, the three stylized facts are still with us. Brazil, unfortunately, took the wrong path, because actually BNDES is much bigger now than it was at that time, by whatever measure you consider. BNDES now is 20% of the total supply of credit, which is an astonishingly high number. So we're talking about dismantling the system, and now actually the system is much larger now than it was before. FGTS is actually much larger than before as well. Because of this period, there was a very interesting process of formalization of labor force relations. So actually, the number of workers under the formal system subject to compulsory savings is much larger now than it was. So for two different reasons, you had actually the distortions magnified over the past years. We had some progress in capital controls, but it was, let's say, ashamed progress, because central bank never announced that it wanted to release capital controls. And on judicial system, it's hard for me to evaluate what happened. But the fact is, our domestic instruments still held in shorter term than short duration than offshore long instruments. So the question is, I think the stylized facts remain. Basically, Brazil moved the wrong direction over those years from the viewpoint of how to address the issues I'm talking about. The question is it surprising that we haven't reduced interest rates so far? I think it's not surprising, because we have not dealt with the critical issues. Remember, the critical issues is not about monetary policy, fiscal policy, or real economic cycle. Those can explain why real rate of interest should be above or below the equilibrium level. But why is the equilibrium level so high? That's the key issue. And the only way to address this, I still have my own, keep the same view, is by reducing legal uncertainty and by moving in a straight way to full current account liberalization, but to currency convertibility, and not doing the wrong steps. That's exactly what Brazil did with BNDES and FGTS. So it's not surprising for me that we still have exactly the same configuration, because we have not addressed the key elements of the problem, and we have moved wrongly. When we did what should not have been done. That's with BNDES and FGTS. How is the situation from now on? Can we have a better explanation, let me try to address, of the three stylized facts? I should confess to you that I've not come up with a better explanation. So I think actually the reason we have high rates of interest in Brazil is this combination of capital controls and judicial uncertainty. And without addressing the two issues, we'll not be able to have lower rates of interest in Brazil. Are we working toward that direction or not? As of now, I don't see it. I cannot evaluate from the judicial uncertainty viewpoint. All I know is that the difference between offshore and onshore market remains. And from the view of capital controls, the progress was done, but as I told you, was moved in a very shameful way. Central bank was never announced the program and never did what should be done, that making the currency fully convertible. We're the opposite case of China. China is announcing a program for full convertibility. Brazil is moving in that direction in a shameful way and never announcing what they actually intend to do. So all in all, I really don't see why we're moving in the right direction. So it's not surprising for me that for all of those reasons, interest rates in Brazil continue to be extraordinarily high. Thank you.
Thank you, Professor Pérsio. Let's move on straight to Professor José Virgílio Vita Neto, the experience of Itaú Unibanco. José Virgílio Vita Neto is the legal officer of Itaú, responsible for labor, litigation, tax, and transactions areas since 2011. He graduated law school at the University of São Paulo in 2000. He holds a master from University of Salamanca, as well as a doctorate from University of São Paulo, both of them on contracts. In Salamanca, his work was awarded with the Trabajo de Grado Prize. So welcome.
Good morning. Thank you very much for the invitation on behalf of Itaú and our legal department. We are very honored to be here and to be able to share our experience in litigation and banking litigation here in Brazil. First of all, I would like to begin with a quote of someone who doesn't need any introduction, and that sums up our view about contracts. A company is a nexus of contracts, once said Mr. Coase. And this is how we view, and this is how we approach the contract issue. The contracts are our soul. We sell contracts, we buy contracts. We are a big financial institution. We don't make iPhones. We don't make cars. We sell contracts to our clients, and we buy contracts for them. More, we hire people executing contracts with them. Contracts are the way we organize our activity, our entrepreneurship here in Brazil. In this sense, we are heavy users of the legal system's remedies for contract enforcement. To recover our credits or to defend ourselves, we have to make use of all the remedies, all the legal remedies that are available here in Brazil. And we do so many times, and I would like to say more than we would like. When we look at the remedies the legal system provides to the parties here in Brazil, we can say that they are not sufficient. That is because one big reason, too often the courts are the first option in Brazil, the first recourse remedy here in Brazil. I will show you some superlative numbers that enforces or that goes right in the direction of Professor Arida's speech and show the legal uncertainty that we live here in Brazil. I would not like to move on because this chart has a so beautiful photograph of Rio de Janeiro, but I must. So when we look at Brazilian context, at Brazilian litigation context, I have numbers of 2013. We had about 95 million claims in courts in Brazil. In the year 2013, there were 28 million new claims in courts in Brazil. Every 2 hours, a new law, rule, or regulation is enacted here in Brazil. We have more law schools in Brazil than all over the Western world summed up. This is an explosive environment for litigation. We are convinced that to tackle this scenario properly, we have to change the mindset. It is of little use to believe that one can handle all this litigation the traditional way. And in Itaú, we challenge ourselves to do so, to change our mindsets 5 years ago. And I will share these experiments with you. To begin, let's look at Itaú's number. We are a very big financial institution. We have more than 85,000 employees. More than 60 million customers are served by us. More than 1,000 customers are served by us every minute. We process for more than 4 billion transactions only over the internet every month. So we are exposed to all kinds of litigation, to all kinds of contractual breaches, and so on. With that number, it's not hard to imagine that a fair share of the Brazilian litigation is upon us. And so it is. We deal with roughly 1 million claims. Itaú only deals with 1 million claims. We are put as plaintiff or defendant in about 20,000 new claims per month. We deal with 60,000 labor claims. 70% of our former employees file claim when dismissed. This isn't a horror scenario. Horror scenario. You don't want to be a company that has to deal with 1 million claims. We have 500 lawyers working at Itaú. You don't want to be a company that has to have 500 lawyers. Okay. So in 2010, we woke up to this scenario. It was 1 year later, Itaú and Unibanco merger, that was the biggest merger of financial institutions in the Brazilian history. And as a legal department, we woke up to this scenario, and we knew we had to clean up the mess. We knew we couldn't continue to move forward like this, and we had to do something. So we proposed ourselves a new way of managing lawsuits, and it was a very audacious project. We called it Legal Franchising Project. It begins from the start. We wanted to create a new standard for our litigation, and we wanted our law firms that represent us in courts to follow this standard strictly. We wanted to make a good impression to the judges and to the courts. And this is the sum up of our project. It's simple, yet very powerful. The first question we ask when a claim comes to the bank, when we are dragged into litigation, is if we did make a mistake. Have I made a mistake? If so, we will not defend the claim, we settle. If we did not make a mistake, we will then defend the claim. And to defend the claim, there is these premises that show to you that we only defend when we are right. And to be right, is a condition to be right that we have proof that we are right. It is insufficient to believe we are right. You have to prove it. We have renounced appealing every court decision. In our superior court, we have withdrawn about 5,000 appeals that there existed that were appeals that did not make any sense at all. And, as I said, we set a new standard of conduct to our law firms. Our goal here was to be set apart from our peers, other financial institutions in Brazil, that suffers the same troubles that we suffered. We wanted to create reputation. We wanted to create a solid reputation of good faith. We wanted to be seen as someone who does not litigate for the pleasure of litigating. We wanted our relationship with judicial authorities and with our customers to be sustainable, even if when we were dragged into litigation. And I must say, we were pretty much successful in this project. As you can see, some more superlative numbers, but we had dropped our total claims by nearly 90%. We have settled more than 45,000 claims in the past 5 years, and our success rate in litigation of cases that were actually trialed raised, almost doubled, and raised to about 70%. One who looks at this chart must say, wow, you guys did a pretty good job, and you really tackled the problem, and now you can manage your litigation. Now you can look up and say, yes, we won. But no, we did not. We have the feeling that we are going around in circles. This chart, the orange part of the chart, shows the effects of new claims against Itaú in the past 5 years. Although we have reduced our total claims by 90%, now we have almost the same number of claims 5 years later. It did not matter what we did. Yes, we reduced the cost of litigation. Yes, I believe, we created some reputation with the courts. But to the company, the problem is almost still the same. And our project was insufficient to tackle the problem, to solve the problem on its root causes. Yeah, that makes us wonder, what went wrong? What did we not see? Which is the missing link? And to us, the answer is pretty simple. The institutional setting in Brazil leads inevitably to this litigation scenario. For instance, take credit recovery claims that we appear as plaintiff to recover our credits. And I don't know if all you know, but the Brazilian IRS only permits us to benefit from tax credit arising out of default if we file claim. Thousands and thousands and thousands of claims were only filed for this tax benefit. Claims that did not make any sense. Claims that were useless for the purpose of recovering credit were filed. The solution here was simple. We had to change the law. And we think we did it last year when we finally changed the tax law that permits or that regulates tax credit arising from defaults. So I believe that in 1 year, 1.5 year times, that's the time for maturing of the new law, we won't have the scenario of having to file claims only for tax benefits. On the other hand, if we look at the cases where we appear as defendants, we are convinced that we face a true litigation industry. There's an industry working against us, and it's incentivized by threefold reasons. First of all, courts in Brazil, especially the inferior courts, tend to disregard the contractual terms and conditions and to reconstrue the agreement on trial. This is particularly true in labor contracts, where it's nearly impossible to enforce any agreement between an employer and employee. The labor courts disregard anything that was agreed upon employer and employee. The result? It's simple. The outcome of any claim cannot be clearly predicted, leading almost to a roulette game. It's not per chance that our total success rate in litigation is about 50%. You have equal odds of winning or losing because your agreement is not held valid. Second, litigation in Brazil costs zero to the plaintiff. The consumer or the former employee pays nothing to file claim, and the attorneys are retained only at success fee basis. So we have here a free option of 50% odd. And finally, but not least, the compensation awarded by the courts are several times disproportionate to the damage. It's not rare a former employee to be awarded compensation hundreds of times their monthly salary, hundreds of times. I mean, sometimes thousands of times. One person that earns about $500 a month may be awarded $1 million compensation. It's not rare. It's even more frequent. Consumers be awarded punitive damages of thousands of dollars for breaches that brought material damage of $10 or $20. So, put together, legal uncertainty, a free option, and a disproportionate payout, and you have this open invitation to litigation. It does not matter how the company behaves. It's about industry. It's a sad, sad diagnosis, I must say. But we want to improve the scenario. We want to improve our reality. And we keep asking ourselves, what's the answer? And what should we aim for? We believe the answer resides in deep change of the mindset and requires the engagement of every stakeholder on this problem. The courts must not be the first recourse remedy to contractual breach. We have to have effective and efficient methods of alternative dispute resolution. We have to drive contracts and the contractual relationship towards self-enforcement. We cannot rely only on courts to make the contractual performance true. When we look at labor litigation, these methods should work and as an incentive for companies and unions to negotiate key aspects of the labor agreement. And the courts should hold these negotiations valid. The courts today, the Superior Labor Court, does not hold negotiations of employer and unions valid. This must change. I have to be able to negotiate with my union the key aspects of our labor agreement because I will perform my negotiation. And this will reduce the legal uncertainty, and this will reduce the force, the attraction to litigation that today exists in labor markets. Let's put it this way. In civil litigation, we must incentive the customers to talk to us, to bring their disputes and problems to us before going to court. We have to be the first recourse and not the courts. But to incentive the customers talking to us, we have to remove their belief that they will be better off going to courts than talking to us. And our belief here is if we succeed at conditioning, subjecting punitive damages to an unsatisfactory response from our company to the consumer dispute, we will reach this goal. That is, punitive damages should not be awarded automatically. It should depend upon how we as company responded to the consumer dispute, how we tackled his problem and how we tried to solve it. If we did nothing, if we couldn't care less for his problem, then yes, we should be awarded, we should be punished with punitive damages. But should we have done everything that we could and yet the problem was not entirely solved, it seems a bit disproportionate to be punished with punitive damages. We know that this project does not depend on us. And we are aware of several initiatives that in our view, point toward the right direction, especially in civil litigation. Here we list some of them. As you can see, we have government initiatives, we have legislative initiatives, and we have private sector initiatives, all pointing to this same goal. That is, consumers, bring your disputes to the companies before going to courts. We know also this is not a simple matter, and we also know that alone we can make little difference, but we are prepared to do our part. We are prepared to invest as much time and energy as we can to change this reality, and we will not rest until we see this done. Changing of the mindset here is mandatory. What comforts us is that we are not alone. I leave you with another quote of our Chief Minister of our Supreme Court that is engaging these conciliation and alternative dispute resolution methods directly. Thank you very much for your time and attention.
Thank you, José Virgílio. Let's move on, and I'll call Luciano Benetti Timm, who's going to talk about the alternative of arbitration. Luciano Benetti Timm is attorney at law in cities of São Paulo, Curitiba, and Porto Alegre, and partner of law firm Carvalho Machado Timm and Defenti. He holds a master's and a doctorate in law at Rio Grande do Sul Federal University and an LLM at Warwick University. He was a postdoctorate researcher at California University. And Luciano Timm was president of Law and Economics Institute of Rio Grande do Sul, IDERGS, and one of the Brazilian Association of Law and Economics. He was a visiting professor at University of São Paulo and is both coordinator and professor of Unicinos LLM course. Welcome.
So I will turn on the time here so that I can be on time. But I would like to thank Mariana for the invitation, as well as Bruno and George. I met you today, but I'm sure that you accept my name when Mariana proposed it, so thank you. Secondly, I would like to congratulate the students from Stanford coming to Brazil, trying to understand our legal system, something that I've been trying to do for the last 20 years, but I still cannot get it. So when I see the presentation of José about our procedural law, it simply doesn't make any logical sense. And we conducted an empirical study for the National Council of Justice about this issue, and it is still there. And I don't think that the procedural code will solve the problems, because the problems were not addressed at the law. So the idea was to present here a case, a sort of narrative as a practitioner and not as academic. My first reaction was to bring something more theoretical, but then Mariana asked me to bring a hypothesis, a case as a practitioner. So that's what I did. Don't be scared. You're looking at me. Did you brought the old PowerPoint? No, that's the one that we discussed. No, don't worry. The logical presumptions here for my case, and it's a real case that would apply to several clients from our firm, is that our new, it's not so new, but it's a relatively new Brazilian civil code is applicable to commercial contracts. And it has some very broad principles. Some call general clauses of law, such as good faith, such as social function of contract. That is something that I'm fighting to understand since the law was passed. Another presumption, please don't be mad at me, is that the judiciary tends to be paternalistic when construing such principles in case law. This might not be true, and I always hear that from my colleagues in São Paulo. No, our state court is very good, very strict to the contract, but we have to remind that we have more than 25 states in Brazil, so we have to broader perspective and have in mind other jurisdictions. These general, very broad provisions added with a very vague semantic gives the judge a broad discretion in construing the law, which combined with a non-binding precedent system creates uncertainty. And I think this is aligned with what my colleagues just mentioned before. What would be legal certainty then? Would be that the agreement that the parties written and negotiated is applied in its four corners, meaning more literally than in a very vague interpretations. But how to make agreements interpret within its four corners if the principles of the civil code are considered public policy and judges consider themselves to have a mandate to construe this and apply and develop these policies. So the solution we presented to our clients when the civil code passed in 2004, 2005, and it was innovative in a way, was to move to arbitration. In-house counsels were scared to do that move because their job would be under scrutiny, but we had the opportunity to present this idea to the so-called the owner of the company, the controller of the company, and some companies follow that suggestion. So the case is distribution agreements. Manufacturers and the state of Rio Grande do Sul is rich in, well, until now the companies are facing some problems, but in furniture manufacture. And manufacturers need dealers to distribute their products at a lower cost throughout the country, because if you need to put your own company as part of the company or a filial or an entity, it would be more costly. And this cooperation would be built in distribution agreements, under which the dealer would hold the brand and would buy and resell the products. What is the specific problem at stake? The sole paragraph of Article 473 of the Brazilian Civil Code prohibits the termination of the agreement from the principal before the agent has obtained the money he invested to have the rights to distribute. Okay, so if the franchisee or the agent invested 1 million reais, the agreement could only be terminated without cause, of course, without a breach, after the recuperation of that investment, which added to what I mentioned before, good faith principle, social function of contract, balance of contract, would bring to uncertainty to distribution agreements, because as we discussed earlier on, it would be something important for the principal to terminate the agreement without cause. But a problem raised in courts in that way, some judges, especially trial judges, first instance judges, started based on that section that I just mentioned, to give injunctions, preliminary injunctions, forbidding the termination of the agreement, even when the agreement, the black letter of the agreement, permitted that, saying, well, no, the distributor, the agent, has not yet recuperated the money he invested, so you, distributor, is your agent, no, your principal is obliged to keep that agent in that region. And this situation would continue until you have the hearing of the case, and this could take like 2-3 years. So you have to remain that guy there, even not wanted him. And this brings a lot of problems to the manufacturer. You start having different treatments throughout the chain. You lose customers. You have problems of reputation. So again, the alternative was having contracts detailing the investment, saying this party invested certain amount of money, the money will be recuperated in a certain time, and after that the agreement could be terminated without cause. And to avoid the discretion of the judges, the suggestion the bet was an arbitration clause. The idea was that arbitrators would be more keen to apply the black letter of the agreement. Why is that? Because their legitimacy came from the same agreement and not from a public exam that judges normally need to pass in Brazil. So they would be more careful when giving injunctions to keep the agreement. Also, the procedure would be faster, and also it would be confidential, so it would protect the chain, etc. What was the result? Yes, so far we can say after almost 8 years, the arbitration clause protected the industry against baseless injunctions of the judiciary. Also, arbitrators were more careful when deciding these injunctions, saying, well, you can still recuperate the money invested in damages, so let's assess the damages, and there's no need to keep the relationship. And on the merits, I think it's too early to have a conclusion. But so far, the decisions, the awards we as an attorney, we receive from the arbitrators, they were more pacta sunt servanda, which means more relying on the terms of the agreement itself, without construing too much with too much discretion. However, well, everywhere you put attorneys, you have problems with time, with litigation, so arbitration was not that quick as we thought. But I think more importantly, arbitrators partially reproduce the mindset of judges. So it's more or less the same thing, paying more, because courts are subsidized by taxpayers. I think the explanation of having 90 million cases is that the guy who is bringing the lawsuit is not paying. I mean, it's microeconomy 1, yes? I think the first class. Even though they show more higher degree of dogmatic sophistication, if that is relevant, because to me, as a pragmatic, this is not very important, but we can perceive that they have a better dogmatic sophistication when applying the law. Because, of course, if you have discretion and you're not very well at dogmatics, then it could be even worse. But anyway, what we can perceive as an attorney is that the mindset is still there, and there's still some problems in applying strictly the agreement. Some arbitrators show evidentially concerned with the weaker party, something that we have in Brazil. It's a kind of, I think now it's a kind of disease now. We have to be always careful with the weak party. I mean, it's commercial law, come on. With good faith principle, yeah, always good faith is there. I mean, I don't have nothing against good faith, but it's gone too far, the good faith. And let's be honest, I mean, for me, or to me, when we talk too much about something, it's because we lack that thing. I mean, I had a professor who was always talking about sex. I mean, he might have some problem back, at home. Because all the examples were related to sex. I mean, if you're always talking about good faith, come on, man, what's your problem? I mean, and also the Brazilian federal constitution coming as a triumph, The discussion ended by some constitutional principle. That's the so-called constitutionalization of private law, something that I have been fighting for the last 10 years and paying some academic price for that. Paying price doesn't mean anything, Professor Ronaldo, because nowadays it's only a metaphorical thing. It's important to make sure that people understand that now. So what conclusions can be reached? Do I still have the time, Professor?
Yeah, well, not too much.
Can I bargain over it? Can I ask a human dignity principle, constitutional principle, so that you can give me 2 more minutes? It would be against human dignity if you... Yeah, I think as a consumer, as a weak party, I need... coming after the in-house counsel from Itaú and Pérsio Arida, I mean, and then a justice will come after, I think I'm the weak party. I would need more time. So no, the only conclusion is that, yes, in relatively simple cases, and I think distribution tend to be, when you compare to another, like swaps and something like that, this reproduction of mindset is not a problem, but when it comes to a more complex problems, that same mentality could bring a problem then to development of arbitration. And then some in-house counsels start wondering if it is not better to come back to the old judiciary, wait some time in line, but not paying anything for it. So thank you, and that's the next slide. Thanks.
Well, thank you. Just in time. And I just would like to tell that if somebody has any question, you can write a question, raise your hand, and I think that there will be someone to give you some paper. And if we have time, we'll be happy to give the opportunity for the panelists to answer 1 or 2 questions, written ones, please. And now I'll ask Ricardo Villas Bôas Cueva, who is going to talk about judicial enforcement of contracts. Ricardo Cueva is Justice of Superior Court of Justice since June 2011. He's a member of the 2nd section of the 3rd board. He graduated in law at the University of São Paulo. He has an LLM from Harvard Law School with a specialization in tax law. He also holds a doctorate in law with a specialization in environmental tax law at Johann Wolfgang Goethe Universität in Germany. He was an attorney at the state of São Paulo, a lawyer in the private sector, and attorney at the National Treasury in São Paulo, the Procuradoria da Fazenda Nacional, and in Brasilia, and he was the head of the regional office of PGFN. So welcome, Professor Cueva.
Good morning. I'd like to thank Mariana and Bruno for the invitation and the opportunity to be here and learn so much about everything that afflicts us in Brazil. We all seem to be gathered here to agree with Pérsio. I think for different reasons, we all are reaffirming his thesis written about 12 years ago that there is a huge problem of legal uncertainty in Brazil. And I won't deny that. I think the judicial enforcement of contracts in Brazil is particularly endangered, and there is a deep need for reconstruction of this branch of law. My thesis is that in the last 25 years, we've gone through many changes. The Constitution, the Consumer Protection Act, and the Civil Code all created a new standard for contract interpretation and enforcement. Private autonomy, once the main pillar of contract law, has been deeply weakened by the use of broad principles such as good faith, economic balance, and social function of contracts. According to the Civil Code issued in 2002, which still keeps the core rule of the old Civil Code, parties are free to enter into agreements setting mutual obligations as long as there is no illicit, immoral, or impossible to achieve convention, the obligation is deemed valid. But The exceptions are piling up in the new civil code. The first one is the principle of social function of contracts. Same way as Luciano, I don't quite understand it. I mean, I don't quite understand how a business interaction sometimes may be deemed invalid in the name of the social function of contracts. A second exception is the clause of good faith. Objective good faith is an autonomous source of obligation in Brazil now. It implies a series of instrumental duties, such as the duty to perform with care, to exchange information, to protect the other party in his or her property. It might be quite difficult for someone coming from a common law environment to grasp this. Some countries are adhering to this, like Canada recently, apparently, the Supreme Court decided that the good faith principle applies there to contracts as well, but usually in the common law, the idea of objective good faith is quite exotic. Another quite exotic import coming from Germany was the theory of the dialogue between the sources of law, which has somehow reframed the way we interpret and apply the law. This theory basically blurs distinctions between lex generalis, which is the civil code, and lex specialis, which is the Consumer Protection Act, and tends to abolish any hierarchy between statutes. As a result, the Consumer Protection Act winds up prevailing in most circumstances, which is especially pernicious to business contracts. This is why Congress is currently examining a project for a new commercial code. As we know, the Commercial Code of 1850 was revoked by the new Civil Code of 2002, which encompasses business law provisions. Some academics think that time has come to reshape business law in order to make it a proper branch of private law again. This is a very delicate matter in Brazil. Not everybody agrees with the need for a new commercial code, but anyhow, this is being debated in the media, in the Congress, in law schools. Another thing that matters is the rampant growth of judicial activism, which has significantly shifted the common perception of legality and of the role of adjudication. It's not uncommon for judges, by using a theory of balancing of principles, to reshape public policies and to interfere in private agreement, even ex officio. The result has been a widespread weakening of the old standard pacta sunt servanda. A Brazilian court would typically analyze a case by using principles of contract law in a bifurcated test. On the one hand, the constitutional principles of freedom of contract, consumer protection, and social function of contracts, and on the other hand, statutory provisions such as good faith. Legal reasoning does not usually include economic or policy arguments. Looking at the consequences of judicial decisions and the impact in future cases is not usual either, and we don't have stare decisis. As a result, judicial decisions on the same contracts may be vastly different. As José Virgílio knows quite well, we in the Superior Court of Justice decide, believe it or not, over 300,000 cases a year, and many of these cases are revisional lawsuits towards banks, and they have different outcomes, not always the same. And in the court, in our 25-year history, tend to be overprotective of consumers. More recently, however, the Superior Court of Justice has decided a few cases using some degree of economic reasoning. I'd like to focus on two of these cases. In one of such cases, for example, it allowed real estate developers who also finance their sales to charge compensatory interest, the so-called juros no pé. That was quite polemic when we issued the decision. Consumer activists didn't like it, because the practice was widely discouraged by consumer protection agencies. The court, however, decided that such an agreement does not infringe consumer protection rules inasmuch it assures more transparency to what is effectively charged to consumers. On the contrary, an exclusion of compensatory interest would imply an imbalance between mutual obligations. Another case happened basically after the financial crisis of 1999. Lease contracts based on foreign currencies, basically the dollar, became twice as onerous to the lessees overnight, usually car buyers. In the ensuing lawsuits, the theory of imprevision, once again an import, this time from France, was invoked to reduce the economic burden of the macroeconomic change on consumers, who allegedly could not have foreseen the crisis. In some decisions, the economic burden was shifted entirely to the lessor, but in others, the two parties shared the net loss. Most judicial decisions were based on the premise that the consumer, being weaker than the lessor, referred to as hyposufficient in Brazil, could not adequately evaluate the risks involved in celebrating a contract based on a foreign currency. This was criticized by some academics because consumers apparently knew precisely well that tying contracts to the dollar would allow them to escape the exorbitant interest rates charged by banks in Brazil, but at the same time would make them vulnerable to sudden changes in economic policy. Nonetheless, as a consequence of the judicial review, lease agreements tied to a foreign currency in order to finance the acquisition of vehicles for private use practically ceased to exist in Brazil, which deprived consumers of the least expensive form of financing in the country. In a case recently decided by the Superior Court of Justice, the theory of imprevision as well as the theory of objective basis of the contract of German extraction, again, were used by the lower courts to review a lease contract whereby a medical doctor leased medical equipment for his clinic. This time, the court did not accept the argument of imprevisibility because the long history of inflation and the many changes of legal tender in Brazil do not make it possible to conclude that the variation in the dollar value was truly unpredictable, especially since the rules of the Consumer Protection Act do not apply to the case. Furthermore, the court repelled the application of the theory of the objective basis of contracts to the case because such theory applies only to consumer contracts. In addition, for this case, the court repelled using the theory of the dialogue between the sources of law because it is not intended to extend the possibility of judicial review of mutual obligations that were freely negotiated and agreed upon to the entire legal system. I'm reaching the conclusion in saying that it seems that the Superior Court of Justice, as the highest court in charge of interpreting federal law in a uniform manner, has gone through different stages in the definition of standards for the enforcement of contracts in Brazil. In its first years, it affirmed the scope and validity of the changes brought about by the Constitution, the Consumer Protection Act, and the new Civil Code. The importance of consumer protection was reaffirmed in several landmark decisions, and to an extent, the court is now called the Court of Citizenship, the Tribunal da Cidadania. Rightly or wrongly, the court named itself the Court of Citizenship. We're trying to make it better than that. In a second moment, it appeared to realize that excessive consumer protection in detriment to legal certainty might increase prices and make some services scarcer, as was the case with healthcare insurance. In recent years, the court is apparently reaching a new level of maturity in the way it makes sure that good faith, economic balance, and social function of contracts are observed, but not at the expense of legal certainty or of the freedom of contract. Thank you.
We have one question here, and it's addressed to José Virgílio. And the question is the following, and I guess we have time just for it. Is it possible that a new perspective in corporate governance, involving stakeholders' interests into account, could alter the enforcement of the contracts and induce the litigants in Brazil?
Thank you for the question. If I correctly understood it, the point is, what about corporate governance in this scenario of litigation in Brazil? I should say that the biggest companies in Brazil still have owners. We do not have control over our stock market. We have owners that are family-owned companies. For example, Itaú, for example, the biggest banks, for example, the biggest companies of steel, etc. So the stakeholders, let's say the shareholders, are looking into the litigation problem very deeply, and while ashamed of their companies should be dragged to court thousands of times per month, they are also preoccupied with the effects of this litigation. So when we talk about shareholders' corporate governance, I think in Brazil we have a level of intervention of the shareholders more present than in countries where the control of the company is market control and not family-owned. When we talk about corporate governance of another kind of stakeholders, such as employees, or such as the civil society, or the courts, or the government, etc., this is what we are trying to build. We are trying to bring the other stakeholders, the outside stakeholders, to the problem of litigation, and working together with them to build a solution, to build these called alternative methods of dispute resolution that can address the problem properly. We cannot do it from the company. The courts cannot do it. The Superior Court with 10 justices ruling all private law cases cannot do it alone. We have to have the society alongside us. So when we talk about modern corporate governance and talk about bringing all the interests to the problem, yes, that is how we see the solution to this problem, and that is how we are trying to work to help build it. It's not going to be a Itaú solution. It's going to be a Brazilian solution to the Brazilians' litigation problem. That's how we see it. I don't know if I made myself clear.
Well,
I think so.
thank you. Well, since we are running out of time, we are going to move directly to the next panel, and we cancel the break that was in the program. So let's move on and try to improve our time. Thank you.